Thank you for registering for this webinar, in which we are presenting an update on the H1B visa. My name's Mo Sayed. I'm a principal immigration attorney at the Offit Kurman Bethesda office. In the next 30 minutes, I would like to cover at least an overview of some of the historical the H1B visa, which has been the subject of much discussion recently. It's a little challenging because I'm sure there's a variety of different people on the webinar that have some may have a lot of expertise already, some may be attorneys, and others may be doing this for the first time. And then there may be a mix between employers and employees. So I want to keep this at a general level. If you have questions, please email them to me at mo.sayed@offitkurman.com. Also, the webinar and the slides that hopefully you all are able to see if you're on your computers. And if you're not on your computers, or if you're dialing in and you want to see the slides later on, they will be sent to you, or certainly send me or us at Offit Kurman an email, and we'll send them to you. So the H1B has been in place for several years. There's been a certain practice and process for a long time, and very recently the slide shows the highlighted portion, which is the H1B pre-registration. This is the latest and greatest update. There is a pre-registration process that has been implemented starting this year, and we're all right now at a very appropriate time listening in and talking about this issue, because the deadlines are coming up fast. They're going to be in March, and I'll provide more details about what this all means and what this might mean for employers and employees in this area. So first, hopefully you all can see the slide, and what I want us to do is focus on the numbers. So just as a background, the H1B visas for new Hs, so this is what also is important to know. These are for new Hs, not for renewals or transfers. This is for new Hs issued for works employment starting in October of 2020, or of October of a given year. These positions start, they can start only on or after October 1 of the year in which you apply. There are 85,000 positions, or 85,000 spots or visas that are authorized each year. As you can see, in the last 5 years, between 2013 and 2017, the average of visa petitions filed was just almost shy of 200,000. And what that meant was that only 85,000 of those were selected, and those were not even, the applications were not even viewed, right? Like, so they were put into a lottery process, random lottery, out of which 85,000 were picked, and the rest of these packets, which in the old system, up until last year, attorneys and clients had to prepare full packets, meaning provide all the legal documentation, often voluminous and time-consuming and expensive, and the attorneys had to do all of the work before they submitted. These were submitted on or during the first week of April. So all of the work was done and everything submitted, but many of these petitions were not even entertained, and they were simply just, returned after several weeks of mystery and suspense. The employer found out that their candidate did not make the lottery. The government realized that this was inefficient, and there's an effort to streamline things, and also with the use of online tools and computerized systems, the USCIS is moving towards an electronic pre-registration. What it does is, and I'll talk about the specifics of the registration process later on, but essentially what they're doing is that they're avoiding the situation where, like, I like to use these examples, like if you're a skier and you show up like with all of your gear and you've got your skis on and you're right at the door, you want to get on the chairlift, and they say, hey, sorry, you didn't make the lottery, you can't go. Or if you're like flying standby and you've got all your gear and everything ready to go, but you're turned away at the door. That was something like what the H1-B process was like before. But now what they're doing is they're doing a quick pre-registration where employers will sign on, employers and attorneys will sign on, enter some basic details about their cases, not any documentation, not any fully supported H1-B petitions, but submit a short, quick registration, and within a few weeks find out if their candidate was accepted or not, and then, only then, prepare the full legal documentation and submission and pay the fee and engage in a process that may then lead to an approval. Okay. But registration does not mean that you've got an approved case, but it means that you're in the process, and so then we've limited the number of actual full paper submissions to 85,000, or however many end up applying. So that's, in a nutshell, the effort is to reduce these numbers and reduce the waste and be fair to employers, which a lot of times employers would have dozens of cases filed with fully paid legal fees and they weren't selected. So so next slide. I just want to do a quick recap of the H1-B basics, and some of you might know this already, so just bear with me. So the H1-B is a temporary work authorization for an employee. Typically, for example, right now, a lot of the foreign students that are coming off of their student visas, if they're graduating right now with bachelor's or master's degree in this spring, employers that can, are making them job offers for work that requires a specific bachelor's degree. The employer has to show that they have sufficient work available. It could be full-time or part-time. They have to show that for the duration of the work that they've got enough work. They don't have to show that they have not found any qualified U.S. workers, which is something that is required when they're going for a green card. The employer has to demonstrate that they're paying a determined prevailing wage for the geographic area where the job site is located. This process is known as a LCA, which is a labor condition application. It's a quick online process with the Department of Labor. And then finally, when they've collected all this data, they can then submit the petition to USCIS. They will take some time to review it, approve it, and then if the employee is already in the U.S., they can, they'll switch, for example, from a student visa to a work visa and continue to work. If they travel outside or if they're located outside, they will then take this approval to a U.S. embassy or consulate and apply for a visa, have a quick interview, and come back to the U.S. So just a side note, my own personal experience, I myself came to the U.S. As a foreign student and then went through the H1-B process and then the permanent residence petition and then U.S. citizenship. So I've had experience in all these stages, and back then it was simpler and quicker. It has recently, in the recent years, become a bit more challenging for employers and employees, and certainly for the attorneys that work for them. Okay, so and this is like, to my last point, the approval rates have gone down. This data is like for all H1Bs, so this may include others which are uh, not part of the lottery process. So there are renewals, transfers, and if you are a nonprofit research organization, you don't have to get into the lottery. You can apply any time of the year, and you have unlimited availability. So this is something to keep in mind if you're such an organization, if you're a nonprofit research organization, you are allowed unlimited H's, and you can apply any time of the year. However, the ones that are subjected to the lottery, and overall, the percentages are down, like from almost like 96% down to about 85%. There are a lot of requests for evidence, which means that the RFE, as the term that attorneys use, is when we work very hard, we submit a very thorough, detailed application packet. Oftentimes, it's for a position that the service, the USCIS, has approved in the past for other employees of the same employer, but we get the petition reviewed and a letter sent asking for a whole list of documents and basically challenging the legality or the sufficiency of our filings. And so those went up significantly. 40% of H1Bs were subjected to RFEs in 2019, which is much higher than historical trends. And then the ones that did get RFEs, many of them were denied. So the approval rate was lower for them generally. That was about 65%. For those that are interested, or the lawyers on the call, this is the very detailed, specific definition of the H classification, which is a specialty occupation. And what it boils down to is the service wants us to show that the position requires a theoretical and practical application of fields of study that are only available or which can only be acquired by a bachelor's degree, and a bachelor's degree is a minimum requirement for entry into the occupation. And this is where a lot of the complications arise, is this definition. So what we are seeing is, again, that's the regulation, and you can look that up for a lot of details in terms of what types of evidence are required to prove the specialty occupation. And like I said before, sometimes even if you have the most detailed evidence, they're still going to send an RFE, and you've got to be prepared to back up your petitions. A lot of times, I have had to reach out to experts, academic experts, professional experts, professional associations, trade associations, to get letters of support for certain occupations which the service challenges as not a specialty occupation. If any of you need a list of the kinds of documents that are submitted, I can certainly provide it to you. You can email me. But it's important to address each criterion for the specialty occupation. So, I'm going to try to move along here because we have much more to cover. This is just a sample of this slide, which is the job duties chart. We are now seeing a lot of requests for evidence where they ask for the percentage of duties or the percentage of time spent performing those specialized tasks, and breaking down, sometimes providing a daily outline of their day-to-day functions, sometimes overall the job description broken down into percentages, and the employer has to show that more than half of the work that's being done is of that specialty occupation nature, and then explain in a lot of detail what are the technical knowledge or complex technical knowledge required, and then relate it in the last column to the educational requirements. For example, specific courses or specific bachelor major in which teach that type of knowledge. So it's pretty meticulous. And again, like I said before, like the government uses a very narrow interpretation of specialty occupation. So they will say that, for example, only one major is allowed for if you have more than one major of study that can provide the education for a particular job, then they are saying that, oh, that's too general, that's not specific enough. So therefore, we've got to be careful when we submit these, and this is part of the assessment part that the attorney can do is, how do we cast our evidence? Like, how do we, use the educational background of our employees to gain maximum advantage? And how is the employer crafting their job descriptions carefully? And then certainly we want to narrow the gap between the degree and the job, the occupation title, right? So I'll give you some examples where I had RFEs recently where we had an accountant, an auditor position, and the employer required they were taking applications from folks in accounting, finance, business management, and the government said that was too general for this position. However, on all of these, and I won't go through the details of the next two, but you can see that sometimes you need a combination of these, or any one of them can work, and it's still a specialty occupation. But the government's pushing back on that, so these have to be done pretty strategically. Fortunately, there was a really good case that came out from the federal court in D.C. That kind of pushed back on the government interpretation and said that, essentially that it's nowhere in the law that does it say that only one degree is a requirement. So we have had a good case law come out, and all of these cases were successful eventually, but it was a lot tougher fight than it should have been. Alrighty, so here we go. Pre-registration. I think the main takeaway with pre-registration is that even though they're allowing this pre-registration, because of the ease of registering, you can imagine now some of it is speculation because this is a new system and we don't know how it will roll out and whether all the mechanisms and computer software and all the moving parts will actually operate as desired. But the idea is that employers are being required to be selective. So before you register, you're supposed to make a case assessment and go over all those things that I talked about, like, do we have a related degree? Is the occupation of a type that's a specialty occupation? Are we paying the prevailing wage? Do we have work available? So the attorney and the employer need to do this assessment before registering, because if it turns out that we didn't do our due diligence and we took up a spot in the lottery, and then eventually it turned out that our case was, frivolous, there are penalties for that for employers. So while there is a ease of use in the system, there's also a greater responsibility for the employers to vet and to engage attorneys to assist with cases that may be questionable. And also, like, if you register and then you eventually don't end up filing a case, there are also penalties for that. So that's what, we'll see how this works out. So this is I think the main point here is that one of the other issues is that on the entry-level positions, the government sometimes takes a pretty absurd position. They're saying that among the levels of experience required for a certain job, so you have a level 1 is the entry level, the level 2 is intermediate, and you have an expert, or a advanced, and then on number 4 you got an expert. And each of their wage levels is certainly it increases as the level of experience increases. And the government's taken in some cases the position that a level 1 entry-level person doesn't necessarily need a bachelor's degree, and you could have that job done by someone with an associate degree or with a work experience, a lot of work experience. The problem with that is, for example, we know that for example, an entry-level lawyer is a level 1, but they need some pretty specialized knowledge. So this is also another area where lawyers need to push back, and employers, I mean, where they can, if they truly can say that we have a level 2 work available, for sure, then level 2, they should select level 2. However, that will come with a higher salary, and the type of work involved in a level 2 will be different from what a level 1 will be doing. So it's challenging. So there's specific guidance on computer programmers. It's a whole separate topic. I'm going to just mention it because there's some specific advice in that area. And certainly in our cases, like, the other big development, or I guess there was a presidential executive order on Buy American, Hire American, which I'm sure you've all heard of, and some people refer to as BAHA, BAHA, B-A-H-A. I kind of messed that up, but a friend of mine said BAHA. But so we need to now provide evidence that we're creating higher wages and employment rates for U.S. workers. So usually that comes in terms of a statement from the employer, just attesting to that, and that this H1-B worker will create additional U.S. jobs, or they'll create a benefit for the U.S. economy. And usually it's not hard to do, but one has to pay attention to that requirement in the filing. All right, so availability of work. This slide lists the kinds of documentation that you will need to show availability of work. I think that the point to note here is that for third-party placements, startups, and small companies, the requirements are a little bit more exacting than for established bigger companies. But hopefully some of these examples will help. And for startups, I've done startups, and usually the business plan is very important. Okay, so quick, I think we can cover the registration process and some of the issues in the registration process. I mean, I think one of the changes will be the billing models, like how companies budget for legal expenses, and what might be some special considerations when it comes to student visas and timing issues, because that's going to change. What we are seeing, I mean, in response to the registration process, is really just mixed feelings. And we feel like, okay, well, on the one hand, it might be really good, but what if it doesn't work? And so there's some uncertainty. And you're not alone. That's why we're here, to help you navigate through all of this. And hopefully these next couple of slides will provide a little bit of a guide to how things will work. So first, we need to look at the timing. All right, so we register March 1 to March 20 is the window, okay? Results will be announced by March 31, so we'll know whether our clients were selected in the lottery, okay? Employers and attorneys will be notified by email or text. This one's really interesting because the window for filing the actual petitions is now longer. So we have 90 days, where before it was just literally 5 working days in April. So I personally kind of like this. It gives us some more time, and there's not all this like crunch to get all these cases in 5 days. But it does have a flip side. So this is the website where attorneys and employers will go to create accounts. The attorney portal is active. The full employer portal is not yet active. It will be, I believe, early next week, February 24, I believe. And so then we can go ahead and create accounts. I have some screenshots that the American Immigration Lawyers Association has provided to us immigration lawyers of what the H1-B registration portal looks like. It's like any other online form. It's got fields that the employer fills out, and I've been using questionnaires to just have the data available so that this can be done quickly when it becomes live. So there you are with the types of information that is needed. Pretty straightforward, not a whole lot of detail. Company name, beneficiary's name, and some other basic details. Then we have on the computer side, what they've done is that online there's a two-step authentication process which they call a handshake. So the attorneys will submit a G28 form authorization from the employer, and the employer will set up an account and identify the attorney as an authorized signatory. And basically after that happens, then the attorney can go and set up an account under that employer's profile. What this does is it creates a passcode that the attorney will provide to the company, and then the company will sign in to their account and enter the passcode, and then the attorney will be added as a representative. And it's kind of like, the thing is that I guess, sometimes we work with multiple cases for the same employer. So these registrations are not just for one individual, that you can have a bulk registration. And when you're working with multiple employers, the IT side can get somewhat, intense, but there is a process to keep it all smooth. There's a $10 filing fee initially, so fairly less burdensome for the registration. A $10 filing fee is paid. Beneficiaries can't pay the fee. It's got to be done by the employer. And just like I was mentioning before, the employer, must review and approve the info and do an assessment that yes, this is a legitimate H1-B case that meets all the criteria. And once the company approves it, the registration can be submitted. So it's a collaboration between the attorneys and the employers. There is a process to edit a registration after it's submitted in case there's any issues, and there's two different ways because there's there might be single cases or batch cases, and there's a different process for editing them. And you can also re-register if there's mistakes done on the initial one, and you've got that 20-day window. I think I've covered some of this earlier. Just be careful that the candidates are actually fully vetted. The documentation about the job offer, and then the commitment to actually go through with filing the H1-B. And so, something like, oh, let's just go ahead and register, and then we'll decide if we file or not, that is going to be discouraged. So it's got to be done seriously. If you do a registration, you must have the intent of following through with it. Okay, so here's some worst case scenarios. Like, what if the registration system doesn't work? What if it's a big failure? Do we go back to the paper system? Some of the recommendations are to, still keep that paper file. Keep that. We used to create a public access file done with all the data required. There's a LCA requirement that traditionally was done before the filing, so it's wise to have all the paper version of the filing ready to go in case there's a problem with the online registration system. We're recommending it be done before April. So hopefully these worst case scenarios don't materialize, and we'll be fine. So I'm close to time. I'll maybe go over by 5 minutes here so that I can cover these last couple of slides. This is basically the American immigration lawyers have provided suggestions in terms of how to set up the workflow and in working with your attorneys, what you want to ask them to do. You can have a full service due diligence and filings. I'm going to keep this fairly brief, but the main thing is that there are different levels of service and different timings that can be provided by attorneys, right? And so you got to select the one that meets your budget and your timing constraints. And because there's the 90-day window to file, it's gonna typically be structured along the filing time frame. So you might have some petitions filed before or ready to file before April 1 or on April 1, some that go from April 1 to April 30, others that go from May to June, right? And it will depend on the time constraints of your employees. And mostly that is the case with the student visa holders, which are their time of their student visa practical training is running out. So if you've got someone whose OPT practical training student visa is expiring April 4, then you must try to file it before April 4 so they get the benefit. If they have a registered H and an H filed before April 4, then they can stay while it's pending. So those are the considerations that go into timing and selecting what package of legal services you are selecting. All right, so here we are. Okay, not bad, just a minute over time. Again, questions or comments, please email me. I have my email address on the slide. If you're listening in, it's if you don't have the slides, it's mo.syed@offitkurman.com. Again, the slides and recording of this webinar will be available. We're going to send, I think, an email, and then if you have certainly questions or others that are interested, you think others may benefit from this presentation, please let us know, and we can send it to them, and they can register and listen to it later as well. So that's me. That's my phone number, and you know how to reach me. It's been a real pleasure presenting to you, and I hope that this has been helpful. I would love your feedback, suggestions, other areas that you would like covered in future webinars, so please feel free to get in touch with us. I hope you all have a great day, and good luck with the H1-B season.